See if that did it. Megan, did that do it?
Yes, I did.
Okay, it's got it. Cabinet versus Colton Alley. Raise your right hand, please. Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth. State your name, please. With whom you're employed. Okay, what do you have to present today?
This is a motion, so I may ask how much is the arrearage on this case? And how much are you seeking in lieu of contempt?
Sounds reasonable. Patrick Taylor, raise your right hand, please. Swear the testimony about to give is the truth, the whole truth, nothing but the truth. Proceed.
Is there an arrearage in this case? How much?
$1,514.42.
What amount are you seeking?
$400 on March 3rd.
Sounds reasonable.
This is yours.
Greta Mason versus Darren Mason.
No, we have agreed over this.
Okay, does that conclude your docket? Thank y'all very much.
All right. I just want to check the clerk on case, just make sure you've got a file.
At 1:15, domestic violence docket. Karen Smith versus Jacob Smith. And Jacob Smith too. $18D 0021-40. Okay. I can't find a petition in here. Are there lawyers involved in this at all?
I do have a lawyer, but
Who is your lawyer?
Wanda White.
Yeah. And knock on the door and see if she's involved in this.
She's not involved in this particular incident.
You represented this lady in her divorce, is that right? But you don't in the EPA, Karen Nicole Smith, so you don't represent her in this.
No, I hadn't talked to Karen in a while.
Okay, thank you. Jacob Allen Smith, has he been served?
Yes, he was on January 20th.
Yeah. Well, Ms. Karen Nicole Smith, in your affidavit said, don't make him come down there, but it doesn't say any specific threat of violence or anything he made towards you, right?
Right.
Since you got this, has he been okay? He hadn't been around?
I
or
don't
any-
have any contact with him. The only time I ever have contact with him is when it's time for him to pay his child support and they're getting a warrant for him. And
Yeah.
he calls and does all the threatening and all that.
Yeah.
So this past time when that happened, I called the officer. The officer said the best thing to do is come up, make a statement,
Yeah.
get an EPO. I've not heard from him since.
Yeah.
It's over and over and over. It's process.
Well, I wish he was here. What I have a tendency to do is keep this in place and have him subpoenaed or summons to be here, okay? Have him ordered to be here on March 3rd. Because I want to look him eye to eye, explain to him something. I really don't know whether you have enough to get a permanent DVO, but I understand from what you say and what you say or what you're going through. And we might be able to ameliorate that. If he gets here and testifies, you might have enough. I don't know. But if we get him served and he doesn't come here to pay attention to it, I will enter a permanent domestic violence order on him because he just needs to understand it would indicate that he's not planning on changing his conduct. Okay.
Right.
Okay. Thank you for being here.
Thank you.
Melissa Nelson versus Jackie Nelson and Jackie Nelson versus Melissa Nelson. No, come up here and y'all stand toward the center and keep each one of them on the outside. Sure, Mr. Garmin will throw a body block if he has to, so wait till they get in here. Okay. You also had a, that was sent to the commissioner, wasn't it?
I'm not sure where we're getting that at.
Yes. Megan, would the motion for custody refer to the commissioner?
Yes, it was.
Okay. Yeah, so let's do that.
Although, Judge, now that I'm thinking about it, I don't know if Mr. Song might have a conflict.
What conflict is he at?
Judge, he has done the contract work for these parties for some time, including in the last 6 months, as I understand. He's their family attorney.
I don't think he mentioned that to me when I was well, if I had any cases with him. He stated he didn't work with both of them. And I was with him.
Well, a good agreement's better than a hearing if we can get near one. So let's see where we're going on this thing. Now, tell me, both of them have a secret protective orders, right? Have y'all talked to him about this? Is this Melissa's statement here? On the night of 2/6, Jackie came to my house, stated that he would burn my house several times and I could have his half of the ashes. Also stated to the minor kids that the house may catch on fire due to all the threats myself and the children are afraid. Okay, now. gentleman's statement here is on 2/6, my wife texted me and told me that I could come over and see the kids. We had lived separated and I filed for divorce after I moved out. I arrived at our house after dark and see the kids. She followed me out and insisted that I move back in. I said no. She grabbed me by my wrist and rapidly stepped into me as if she was going to butt my head. I turned back. I said, "Get a charge on you." She said, "She has been mentally unstable, carrying a gun in her purse, threatening third parties. She's been talking suicide. Fear my safety and safety of my children. Only had been going to see my kids with her permission. Not threatened her. I filed for divorce 2 weeks ago. Just had her serve with motions and court dates. She's been up in the door. Position with me on the porch. I don't know what this, her ring, what should prove what happened. I guess that's a button on the door, record stuff. I had someone call me last night about an EPO or DVO case. And when the person started to tell me who was involved, I told them that I didn't want to hear the names. I don't know whether it was about y'all's case or not. But in any event, I'm not prejudiced for that. But anytime when somebody tries to contact me, I'll inform. So I really don't know anything. Pull your mask above your nose there, if you will. Both of these, the only thing that bothers me, if true, is the threat to burn the house down. These other things seem to be. Were there any witnesses? You have any witnesses to this statement? What were they today? How old are they?
14.
Yeah, and you're gonna have them, they heard him say that he was gonna burn the house down, or did you tell him he said that? How did they? Yeah.
Just gonna say, she just got served her EPO yesterday afternoon. I had heard about it before yesterday afternoon. I was in Fort Assembly all day yesterday and down here today. I have not really had a chance to prepare for a hearing on this or even discuss it with her. And I just got hired on the divorce case on Tuesday. And I asked this morning for continuance on all the issues and she was willing to do so. But I will request continuance of the DVO cases. And I was notified of this yesterday.
The problem is it's not working. No reason to schedule.
Well, the problem is either if you are to believe the mother, and I have no reason to believe or not believe her. If you believe her that one of these children either heard that or has been told that, then you could have a relatively hostile situation. If I were the father, I wouldn't want to visit with a child that made the allegation. They said I was going to burn the house down, because they might very well say he does something or says something else that he might or might not say if it didn't happen. Follow what I'm saying?
I do, but he lives with his grandmother, and the children are with him. They get
You heard what I said as far as my reservations about it. Evidently, you don't share those reservations.
I just know my client wants to do with his children. And he's
Well, sometimes our clients want to do things that might not be in their best interest. I've had clients because maybe sir, maybe you don't think that your child would lie about what they said. I don't know whether the child would say that or not. If the child says you threatened to burn the house down and you didn't say that, which you keep shaking your head that you didn't, I have no reason to doubt your word either. You see what I'm saying? But what if the child did say, I know, listen, a lot of people get accused of stuff they didn't do. What if the child does believe that you said, or says that you, that you heard you say that, then you need to be careful around that child. You understand what I'm saying? I hope it's not true that you didn't say it. And I also hope it's not true that the child would say something that you didn't say, but it happens every day, you know? Now, as far as this is concerned, I really don't know whether either one of these things rises to the level that we ought to burden this case down with EPOs or DPOs and things like that. I think you can practice this case without those. And I'd like for y'all to go back and talk to your clients to see if you want to proceed with this case in some way and try to be reasonable about these things, because I'm telling you, if you start going down the road of making threats or telling children that their daddy's going to burn their house down or vice versa, and if he said that, either way, it's not good for these children. It is not good. It will have long-term implications for them. So y'all go meet with your clients. I'm going to drop you to the bottom of the docket, see if you can reach some kind of accord on how everybody can start acting like adults. Evidently, your marriage is over. You know, now what we got to do now is get you know, I don't know if there's not custody issues, why the commissioner couldn't hear the property issues if you can't agree about the property issues. I don't know how long have y'all been married?
16 years.
Yeah, and have you ever separated before? Have you ever thought about counseling?
I've asked him if he said that I'll take. I've tried to save our marriage because we have 3 children.
Yeah. Well, then if she has erratic behavior, maybe it's one of these in sickness and health situations. Maybe if you think that she's got some kind of issue, pull that up over your nose or I'm gonna have an issue with you, okay? Okay, maybe she needs some help. Okay, well, then it's maybe a good time for us to step back away from this. I don't know how you still feel about her. I'm not going to ask you that. That's a private matter, okay? But it could very well be that we could get some counseling somewhere with the stipulation that someone needs to do some separate counseling about these sort of things. Because I have found out, how old is your oldest child?
He'll be 15 and 20.
Well, it'll just seem like tomorrow, maybe hopefully 6 or 7 years, when there's a next generation coming on and y'all won't get to spend Christmas or Thanksgiving,
I agree.
you know?
I
Well, I don't want you to say anything else, okay? I understand. So it's just something you need to reflect upon. I had a conversation recently with a friend of mine. It's an elder attorney, and I was talking about people saying they're not happy in their marriages and stuff like that. And he said something that was pretty profound to me. He said, I never thought about whether I was happy or not. He said, some days you are better than others. That's what relation. He said, I was committed to a relationship, and if things weren't going well, I was going to try to work about correcting it rather than whether I was happy, because happy is a fleeting thing. It's an instant thing. It's a perception thing. So I don't know where you're at in the thing, but y'all go meet with your attorneys, see if we can get past this DVO, EPO thing and get some reasonable visitation. I don't see anything in her allegations that would indicate that this man would not be good to his children. You know, I mean, maybe even if he did get mad and say that, I mean, if he did say that, most of us have said stuff worse than that at some time or another. And I'm not saying you did say it, okay? So let's see if we can get some work and see if you can agree on the potential of having some counseling. If they don't want to do that, then we'll let y'all go off and meet somewhere about the property to settle after we reach an agreement on visitation. Okay?
Yeah, just yesterday, we did kind of rough state with them, with the property.
Well, I'm more interested, the immediate problem is the children in visitation. And I don't want like them to think that he's somebody that they shouldn't visit. I don't want them to think that, because that's not good. Unless he is somebody that they shouldn't visit. And if he is, I can take care of that too. But from what I see here, it's not gotten to that point yet. So y'all go your separate rooms back there and come back to me in a minute, okay? Okay, let's go with Nathan Stockton versus Ashley Tompkins.
I think they sent that to the DRC, Your Honor. Is it not?
I don't know.
I believe.
Megan, was that sent to the DRC?
Yes.
Okay. Haley Choate versus Troy Ray.
I believe that's the DRC case as well, Your Honor.
Yes,
Okay.
it is.
Okay. Kristen McGowan versus Nicholas Barber.
That one was supposed to be taken off the docket.
Continued. Tiffany Johnson and others versus Aaron Huff and others. It's a motion to amend. I read that last night. Is there anybody, who are the attorneys in this case? Are you involved in this case?
I'm not. Your Honor.
Would you like to be?
I'm not.
Okay.
You did sign that read order on February 3rd to amend the complaint.
Well, I thought I did. I didn't know. They just had another kind of pleading that I thought they might want to amend it again. So I'll just pass this since I think I already did sign that. Calvary SPV LLC versus Terra Upchurch.
I represent the defendant, Your Honor, but frankly, we did not file a response to the motion because I couldn't get the people in, so not much.
Robert Miles.
What is this motion for summary judgment? What was the underlying debt? I read the still best language, but
Yes, Your Honor.
did you do a request for admissions?
We have asked for, we have done interrogatories, requests for admission for part of that, and it is, at this point, they were given, I believe, around July 2021, so they're fairly
Yeah.
well.
Okay, I'll enter judgment. You got, did you send me a judgment?
I believe there's one of the phone.
Will you check and see if there's a file?
If there's a what in there?
Maybe this will get their attention and maybe
Okay, I'm saying, yeah, I have a summary judgment here. Would you like to get a copy of it stamped, or would this mail it to you? It is possible. Now, I don't know where,
Not every jurisdiction is so generous.
well, they don't have a clerk's office like I do.
I suspect that.
Yeah. Okay. Triad Financial Services versus Davis Tuesday.
Again, Your Honor, for the record, Robert Miles appearing for the plaintiff, this is actually the default judgment motion.
Yeah, I saw that. Okay. Make sure they're served. Are they served? You were the warning order attorney in this? Were you the warning order attorney in this? Well, I thought you just hung on every word I said. I can't believe it. You Triad Financial Services versus Tuesday Davis and Tuesday D Davis. Okay. I see your report here. I see no reason not to sign the interim judgment then.
If possible, I would appreciate a copy of that.
You get that also here.
Thank you, Your Honor.
It might cost you $2 now.
$2. You put twice the price.
That's right.
I assume the court will take my check.
I don't take money directly. If I ever took any money from you, brother, it'd be enough to get a felony. It wouldn't be no misdemeanor. So
Fair enough. May I excuse your?
absolutely. Where you gonna get your copies here?
Thank you.
Yeah. Albert Bell Jr. versus Tiffany Bell. Okay, Mr. Cross, you represent.
Petitioner, and it's our motion for default. I believe that this bill has been served, and we hadn't heard from her, and lo and behold, here she is.
Well, are there children involved?
Yes.
Okay, what is your proposal about the custody and care of the children?
We'd like to have a time. With that presumption, which are allowed the presumption until it's proven.
Well, that's what you want is equal time. So that way he won't have to pay any child support, right?
Well, that's irrelevant.
Well, I just, that's the reason usually what motivates people for equal time. A lot of times it does. Ma'am, you never filed an answer in this divorce case. Mr. Cross, will you move over to your left and you want to come behind the podium there? You're Tiffany Bell, is that correct? Why haven't you filed an answer in this divorce case?
I was told by their pension that if I had nothing to say against any of the paperwork, then nothing else was to be done, it would go to the court, and it would be fine.
So you're good with this, right?
Yeah.
Okay, well, that's another satisfied customer. You got a judgment for me to say.
Everyone, Your Honor.
Okay, now what, on the visitation, how old are the two children? One, how old?
Four,
What about, is it gonna stay with you or stay with him or
seven, eight.
during the week, or what kind of custody arrangement do you expect?
Your Honor, that's.
Well, 50-50 doesn't mean anything to me. That could be 3 days and 4 days or 4 days and 3 days. Is the child doing okay in school?
She's not in school yet, she'll be enrolled though this year.
Kindergarten?
She'll be
Okay.
enrolled preschool.
Well,
The only thing that my paperwork says for visitation is every other weekend and the holidays. That's what my paperwork says.
the paperwork she said she received said every other weekend and the holidays. Is that what you said?
I'm not sure, Your Honor, as far as what that sets forth. Well, I'll tender a judgment and,
Well, I mean,
I think that's maybe.
is the issue the child support? I mean, if she does every other weekend and then gets normal visitation that they get here. We got to sign these things like they're going to be for the long term. It's not like we're just doing it. I mean, there's going to be a big difference when the child gets into preschool and then kindergarten and this and this and this. You know what I mean?
Your Honor, I believe we e-filed a proposed decree which does set forth alternate weekends, two-week periods during the summer, a week of Christmas, rotating the holidays.
That sounds fair.
And,
Okay, and then just let the county attorney's office set any kind of child support situation.
I believe that not file with this.
Well, I said, does it allow the county attorney to get the information to set the child support?
It's already.
Okay, okay. Okay, well,
They might want to make sure, because it just says alternate weekends, 5 PM to Sunday, but what day is that?
Friday, you need to just interlate Friday to 5 PM on paragraph 9(1).
Alternate weekends.
You left out Friday there. So you got Friday from 5 PM to Sunday at 5 PM. Now, do you take the child to church anywhere? But do you take the child to church? Okay, well, if you're gonna have it on the weekends, I'm just telling you, if you decide you don't want to take the child to church, then you need to be thinking about whether or not you're gonna get it back earlier on Sundays.
My mother would take her, I would take the weekend.
Well, I'm not dictating anybody. I'm just saying if we got either one of the parents, either one of the families want to take a child to church, somebody's gonna get the child. You understand what I'm saying? Both of you don't want to take a child to church, it's your business. You know, you'll just deal with it later instead of now. Okay,
Thank you, Your Honor.
okay, thank y'all very much. Weldon Haddix versus Teresa Shelton.
It's just my motion for reimbursement of costs. I think Mr. Song's got a deed tender for distribution. I haven't seen him since this morning.
What kind of costs you talking about?
Proposal order filed. It's the one you had to bring back over this morning.
They brought it back.
Yeah, I brought it up. I had a couple of files. Let me pass over that one and go to Lloyd Owens versus Reed Owens.
Bills in that, Your Honor, today.
I'm here on the Zoom conference, Your Honor. Travis Bell on behalf of Rita Owens.
You turn your camera on?
No, I'm sorry, sir. I don't actually have a camera function on this one. I'm actually at the prosecutor's conference. I serve as the assistant county attorney in Wayne County. All I have is audio capabilities at the moment.
You got a flip phone or what you got? I didn't know there's anybody that didn't have video anymore. You ought to see if they'll provide you one. You not need one here. I don't know. What's the deal, Mr.
Well,
Clark? What? Okay, what is your motion to compel?
Your Honor, we had tendered a discovery request in the form of interrogatories and requests for production. We're just asking for an order to compel.
Well, you got to say, get behind those.
Your Honor, that is correct. We've got the information. We're trying to put it together. Travis, while I've got you, you have to respond to my letter about whether or not we're going to stay in this case or get out of the other.
Oh, yeah. I'll definitely have to recuse from the criminal action. As far as whether or not the entire Wayne County Attorney's Office will recuse, that'll be up to the county attorney, Tom. He'll make that decision. But now I definitely won't be prosecuting Mr. Lloyd or Mr. Owens.
What is the disagreement here, Mr. Cross?
Your Honor, there's a home that's unencumbered and financial assets. Not a lot of that, but maintain disposition of the marital residence.
Do y'all want to get a mediation on it?
I think once we get discovery done, that's probably a good idea. We've had it informally.
When can you get the discovery to them? Let's make it 10 days if you already got it together, okay? Let's do it in 10 days. That way you come back. And the reason I'm saying that, is the rule day comes earlier this coming month. Okay. I'll give you 10 days from today to comply with the discovery. And then I would suggest if y'all can get together, our next rule day is March the 3rd. And the commissioner doesn't have any conflict in this case, I would think, probably.
No, I wouldn't think so.
So if you can't reach an agreement, I might just go ahead and refer it to the commissioner.
That's fine, Your Honor.
Okay, if you can work it out here, we can shortcut it. Agreed orders are always, as Judge Carter used to say, duly depreciated. So, okay, thank you. Have a good time.
That's all I have, Your Honor, for I may be excused.
Okay, have a good time.
Oh, it's bang up time.
Yeah, I know it's tough duty up there. SoFi Lending versus Tracy Cross.
Resolved, Your Honor, our leader knows that.
Okay, 76 Falls Vista versus Freddie Robinson. Did you get me that file? Mr. Connor? I see your namesake up here quite frequently. I see the other Luther Connor up here pretty frequently, so. Did this person bid a piece of property in and didn't follow through? And wonder why this person received a deed to the property here. Get behind the microphone. Well, is there gonna be some provision for him to receive a deed? Is he gonna receive a deed now that he pays for the property? Well, I don't really see signing a judgment that someone could execute on without having some provision about the delivery of the deed. You see what I'm saying? Yeah. Yeah. I'd like for you to add that to default judgment. And then the interest rate down here, you got the post-judgment interest rate at 12%. I don't think that's what the correct post-judgment interest rate is. Now, I don't know what it is, but I thought it was like 7. Anybody? We don't have, I should ask that for a closure lawyer that was here a while ago. Does anybody know what the post-judgment interest rate is now?
Judge, I think it's either 6 or 6.25, 6.5.
Something like that. Check on that. And I guess the 8% per annum from December to February was probably contractual. So if you would just identify that as a contractual rate from that date to that date, and then or that date to today, and then post judgment at the judgment rate of blank percent until paid in full, and a provision about delivery of deed, I'd be glad to sign it. Okay. Okay. Thank you very much. First and Farmers versus Donald Lindsay. Is this a foreclosure on a mortgage? Well, you should know what the post judgment is. Okay, well, I thank you for speaking right up there. I know, I would defer to someone so much my senior as you. There are so few left, Yeah. And even fewer have prospered. Okay, I have read this. It appears that it's in order. Most important thing the clerk always tells me is, do we have the check? And it's right here in little bitty hardly legible printing in it, so. Yeah. Okay. Absolutely, if you make him a copy of the judgment. Jackie Nelson versus Melissa Nelson. Okay, is that the same? That's a part of the same case. Then we have a confidential matter coming up. Have I skipped your case here?
Perhaps, Your Honor.
You're what?
Kavanaugh versus Custody.
What are you here for?
With her.
I knew you'd approach a time in your life where you'd be somebody's driver. I just didn't know. We all get there. Yeah. You're just kibitzing, it's okay. Yeah, I want to bring it up. What you got? I didn't see that on the docket. Yeah, okay. What, you have anything to report? Is this the one where, is this the will thing or something? Yeah. Power of attorney, yeah. You get behind the podium. Where you just elbow her out. She's a little aggressive. You think she's aggressive? Y'all seen her dad? He would elbow you. Go ahead.
Anyways, Your Honor, the last time we were here on this case, the court requested some supplemental briefing.
Yes.
Regarding the legislative history of the state.
At that time, yeah.
Yes. And since that time, we have the defendant take back on counsel, has provided with something with regard to legislative history of the statute that's there.
Did you email it to me?
I did.
Well, we've had a little downtime because of COVID and stuff, and Megan, have you printed that out? Have I seen that?
I'm sorry, I can't hear what anybody says except you.
Well, Mr. Wilkinson said that he sent us a brief on the legislative history of gifting in attorney by attorneys, in fact, and he emailed it to us. Have I seen that? Has that been forwarded to me? I guess.
No, no, you haven't seen it yet. I believe, what's the style of this case?
Happened on the Wested.
Yeah, I believe there was an agreed order signed, extending the time for the brief, and we just recently got one of the last briefs in, and I was under the impression this was going to be taken off the docket since we just received the last brief. I had spoke with Mr. Carroll's office about it, or Mr. Turner's, I guess.
We don't have to take it off. We can discuss it. Have you read his brief?
I did, Your Honor.
Thank you, Megan. Yeah, you filed, when did you file that response?
5 days ago.
That's probably why we're just getting it. Well, what she's saying is that she filed a response brief a couple days ago. Okay. Well, what did you find? What critical aspects did you have concerning his brief, his scholarly work?
Our position is that we don't have to delve into the legislative intent and utilize tools of statutory construction because the statute is not ambiguous.
I'm not really. Are we a legislative intent state anyway?
Well, Your Honor.
I don't think we are.
What Mr. Wilkerson briefed.
Are you pulling my leg on this thing, Mr. Wilkerson? Do you have a loser here that you're trying to pull?
I honestly believe in the space. I've worked a lot of time and effort with the legislative history.
I believed in a lot of cases too, that and really did at the time, and then.
There's a lot hanging on this.
Well, I understand that, you know.
It could be dispositive of this action.
Move over behind the thing.
It's never truly been tested.
Now, there's where we get, you feel like it's a decision that needs to be made to go up. And I can do that. I guarantee you that I am an expert at signing judgments that are frequently taken up and often overruled. So. Yeah, I understand that. Yeah, I could tell by the look in your eyes that you thought it might be a matter of first impression.
Yeah, and so again.
I've never liked this statute one way or the other. I mean, they flipped it back and forth without really giving very much insight into what was applicable and whether people had to been put on notice that executed these things after they were changed. I mean, it's kind of like powers of attorneys being extinguished at one time by divorces, or you know what I mean, or things like that, and people or wills being where even wills being extinguished by divorces, and people thought, well, I left so and so this, and they found out that their will wasn't valid any longer, you know. So what is it? Let's, in a simple argument, without being too great of an advocate on this thing, get behind the podium there. So you'll acknowledge that this document was signed, this attorney, in fact, was signed, was appointed. And at that time, the statute required there to be specific language about gifting in there.
I disagree with that.
Well, I'm asking you what your position is. I just posed that to get you to tell me what your position is.
When the attorney, in fact, the power of attorney instrument was executed during the time period in which the statute was on the books. And we're not going to dispute that. That's not something we dispute.
Which the statute said at that time that they had to be specifically given the gifting authority.
That's the only thing. It does not, Your Honor. It just says, with regard to the statute at issue, it does not say specific. And I believe that's the reason why we're here today and have so much supplemental briefing. The statute.
Unambiguous, what's the word you use?
Yes,
Okay.
I believe that is very pertinent. This is KRS 386.093 subsection 6, which states that notwithstanding any provision of law to the contrary, the durable power of attorney will authorize the attorney in fact to make a gift of the principal's real or personal property to the attorney in fact or to others if the intent of the principal to do so is unambiguously stated on the face of the instrument. And prior to the enactment of that statute, I'm moments prior, and I do urge the court to look at the supplemental brief with regard to the legislative history and how this statute came to pass.
What year was it passed?
It was passed in 2000.
So I'm very aware. I was involved.
I reviewed the tape in which you presided over before.
Yeah.
Yeah. So, yes, and so with regard to that, there was a Wagner case.
Well, but here's the problem is, I've got to go by the language of the statute that was passed when this was executed.
Correct.
Now, was the law changed before this power of attorney, this attorney in fact did these deeds?
To answer that, if I may, Your Honor, the key phrase here is, was the intent of the principle unambiguously stated on the face of it?
I understand.
And that's different than the flat rule which was created by the court.
I understand. Is it unambiguously stated in the document that?
According to Wagner, it is. According to Wagner, in the case of Wagner.
I'm talking about according to the document.
According to the document.
The attorney, in fact, show me the language in the power of attorney that unambiguously states that it was the intent of the grantor party to allow the attorney, in fact, to deed it to themselves.
But it wasn't to themselves. It's on the key fact that this was not a gift to the
Says to themselves or to other parties, doesn't it? That what the statute say? Well, I guess we're dealing with another party. Well, if they're another party,
Yes, that's right.
okay, but I don't, yeah.
I understand. The key phrase here with regard to Ms. Husted, the attorney of facts, power to give, was that she was granted full power to make, execute, deliver, deliver deeds, releases, conveyance, and contracts of every nature in relation to both real and personal property.
Where does it say gift?
We were of the position that it was unnecessary for the document itself articulate the word gift.
I think it's unambiguously stated.
According to Wagner, Your Honor, in Wagner, the word gift was never set forth in the power of attorney document. Yeah, the Supreme Court in Wagner.
Was this predates, which is a case that predates the statute, right?
It does, but it defines the word unambiguously stated in the document. So utilizing Wagner, you can come up, you are given a definition of what unambiguously stated in the face of the instrument means. Wagner gives you that.
What does Wagner say on that?
Wagner, in the case of Wagner.
Just read it to me.
In Wagner, it says the power of attorney executed by the principal in that matter was unambiguous. It expressly provided in writing that Wagner was to have the full power to cash any certificates of deposit which I own or change and redesignate the ownership thereof in his or her sole discretion. If Wagner changed her uncle's accounts to joint accounts, she did what was expressly authorized by the power of attorney. The only question then was whether Wagner's exercise of the express authority granted by the power of attorney was intended by the utmost good faith. This was a question of fact for the jury. That case was decided on December 16th, 1999, and it was ordered to be published on January 6, 2000. KRS 386.093 subsection 6 was a pre-filed bill by Representative Vincent on October the 13th, 1999. And so doing, when Representative Vincent pre-filed that bill, he was relying, he said as much in the House Judiciary presentation of the bill on January the 13th, that he was relying on what was called the flat rule out of Black v. Wagner, which was the Court of Appeals decision, which preceded Wagner versus Black in the Supreme Court. In Black v. Wagner, the Court of Appeals erroneously decided that there was a flat rule that needed to be imposed. And after centuries of common law, in which the utmost good faith standard was upheld, and that the determination of whether or not the power to give was simply a matter of a question of law or a question of fact.
The word unambiguously stated was not in the prior statute.
There was no prior statute.
Well, there was a prior statute of some sort that
Nothing
dealt.
anything with regard to gift.
No, there was a prior statute as far as powers of attorneys and attorneys of facts, and it did not deal with the issue of gifts.
That's correct.
This is the first time they dealt with the issue of gifts.
As far as codifying that.
Yeah, and so any case law previous to that talked about unambiguously talking about this authority was talking about a modification of or definition of a case law, not the interpretation of a statute.
I guess in response, Your Honor, the only thing I would say is that you are presented with this statute, the rule on the statute, with this simple line of that the intent of the principle to do so shall be unambiguously stated on the face of the
Okay, now let me go back to this case that you're talking about. It was a case where the power of attorney document said that they could change the names on accounts with anybody that they said. So that was pretty specific designation of authority that they could do that. Don't you think that's a little different than a general said that they have a right to alienate all the property? If they have a right, if the right to alienate, which is included in every power of attorney document, trumps this unambiguously stated gift thing, then the unambiguously stated gift thing doesn't mean anything. What would you say to that?
I would say that the Wagner court would say that the attorney back in that case was granted the full power
To do the joint accounts. That's what they were dealing with.
cash certificates of deposit and or change or redesignate ownership thereof, their personal discretion.
Okay, so if you could do that to all the property, what does the gifting limitation change? I mean, to say that it has to be unambiguously stated in the document, they said it was in that document unambiguously stated about these accounts, these certificates of deposit or accounts, that was unambiguously stated that they got that authority. So they put unambiguously in the statute. Then if the power of attorney grants them this authority to alienate anything, then unambiguously doesn't mean anything because it doesn't have to be designated. If they said in this new document that you're talking about, power of attorney, they can sell the Jones farm to anyone they want to anyone they want to. Is that any different than saying at the end of the document that they can issue any deeds or transfer any property or anything? Is that different? Is that what they mean by unambiguously? Because it doesn't anticipate a gift. In the case that you cite, what you would look at it to see if what the intent was on the gift and see if they breached some fiduciary duty that they had there. You see what I'm saying in the case you cite? Don't you agree that's what it was saying the court would have to look at?
I believe the court was saying that beneficiaries and their will, which is the same case posture here, contested the transfers and the change of ownership in regard to these accounts. So the determined fact in that case, took certificates of deposit before rights and put them in joint accounts, naming her as a joint owner of the joint accounts. They were saying that was a gift. Same situation as here.
Well, that's probably why the statute was passed.
Well,
right?
No, because the bill was pretty filed before the Supreme Court spoke.
Yeah, but the Court of Appeals had spoken.
Yeah, but the Court of Appeals said something much different. That's
Yeah.
the thing. The Court of Appeals said something much different.
What did they
They
say?
created a flat rule, a per se, that said that attorneys in fact could not give, unless it was expressly stated. Let's see. Court of Appeals.
What is the difference between expressly stating and unambiguously?
I believe there's a big difference.
Tell me what it is.
Between the Court of Appeal said the flat rule is prohibiting an attorney in fact from making gifts of his principles, real or personal property to himself or others in the absence of clearly expressed written authorization to do so. But the statute didn't say that. The statute says that the intent of the principal to do so shall be unambiguously stated. It's a different phrase. And the Supreme Court decided it was a different phrase because they overturned the Court of Appeals in reverse and said that the per se rule is in contradiction to the well-established law of this Congress. And so when Representative Vincent proposed this bill with the House Judiciary, he was discussing the flat rule from black to white, not black or be black. He hadn't read it yet. He didn't see it. It hadn't been published. And so,
Well, that's, you said, what do you have to say here?
Your Honor, because the statute on its face, because when the statute was in place, both at the time the power of attorney was executed and at the time the deed at issue was executed, we're operating under that statute. And because the statute in itself is not ambiguous, there's no reason to look back at what was being discussed by the legislature at the time.
I don't think we're a legislative intent state. I don't remember anybody ever discussing what the legislative intent or something. I think that you have to read the law. Do you agree with that?
I believe well, I would say that the statute.
Do you ever see any cases decided based upon what legislative intent was very much?
I mean, if the statute is ambiguous, yes, and I can pull some more cases for you.
Yeah.
If the statute doesn't have a
Well, I don't think it is ambiguous what it says. It says what it says and the words are easy. It's better sentences that are included sometimes. You can step on over here and I didn't mean to interrupt you.
Yes, Your Honor, and because it's not ambiguous, we don't look outside of the written law, and we presume that words have meaning. What the defendant is asking for is for the court to disregard that phrase that says that it has to be unambiguously stated, or decide that just by saying that you have the authority to transfer property, that necessarily implies the authority to gift, and that's not the case. Because the power of attorney itself does not contain on the face of the document, as is required by the statute, an unambiguous intent.
Okay, who was the gift made to?
It was made to Theodore Kavanaugh. Basically, what happened was Margaret Husted, the power of attorney, made a deed leaving a life estate.
The attorney, in fact.
The attorney, in fact, Your Honor, made a deed where the decedent, the testator, William Kavanaugh, was to retain a life estate in this property, and that Theodore Kavanaugh was to receive the remainder. This is that's the problem here, Your Honor, because that's different than what was in William Kavanaugh's will, because that's different, that's not a valid transfer with 386093 on the books. And so our position is we're entitled to summary judgment at this stage because there was not a clear, unambiguous intent to allow Ms. Husted to gift Mr. Kavanaugh to real property. And because of that, the transfer is invalid.
Margaret Husted was given plenary power. I mean, she was given everything. She was allowed, she had lived with William Kavanaugh for 30 years. She was his closest confidant. They never married, but there will be no testimony if this case was brought to trial, Your Honor, and brought before you. There will not be evidence to say that she was acting improperly whatsoever. There will not be any of that. It was simply, she was granted in her power of attorney document to full plenary power to handle accounts, property, and she clearly stated she filed a verified response before she passed away. Speaking of which, we've been this case set on the books for 6 years, and in that time, Margaret Husted has passed away. The plaintiff's father has passed away. This case is languished to the point where most of the witnesses who will be able to come before you and give you some background and context, members of faith, passed away. Now, after 6 years, they file a motion for summary judgment after everybody's memory is faded, after everybody's gone away. We're not, and we're steadfast in our beliefs that attorney in fact have note to Margaret gave her the power, limited power to transfer.
So your argument is an attorney, in fact, without any direction as far as, unambiguous language, can gift away all of the assets of an estate as long as they aren't self-dealing.
As long as they're abiding by the utmost good faith standards, Your Honor.
Well, I mean, yeah, and that would be, usually it's self-dealing when it's not good faith, right?
That's right, but this is not that. This is not
There's,
that.
I'm not, you just convinced me that it's not self-dealing. So I'm trying to agree with you that this is not a situation where someone deeded it to themselves, where it has to be unambiguous in there. That they have the right, the attorney in fact has a right to deed this to themselves or gift it to themselves. And so we're not dealing with that. We're a longtime confidant and paramour, whatever, is deeding it to someone else, maybe one of his children, right?
Yes.
And you're saying that she doesn't, unless you can prove that there's some fraudulent activity or self-dealing or not, then she can deed everything he's got away under this attorney in fact. As attorney in fact under this power of attorney.
Yes.
Okay. And what's your argument to that?
Your Honor, the standard that he's referring to again is the good faith standard that he's going back to Wagner, which was superseded by statute. In the case, in this statute that we're dealing with right now, it's clear that the legislature said that the intent has to be unambiguously
And
stated.
can you prove that it was a gift?
There's no consideration, Your Honor. You can use the plain meaning of the term.
Yeah, I mean, so you can prove that there was a
That's
consideration.
not in dispute, Your Honor. It's not in dispute that there was consideration. For the
You agree with that?
I'd say that there's on two issues I have to address. One, that there was in the verified answer presented by Margaret Husted, this was done pursuant to the mistake on purpose. That this, if it was a gift, it was a gift plus. It was something else. It wasn't a gift. This was a conscious effort. This was at the will of Mr. Papillon. It's verified by Margaret Husted. Signed, sworn, verified response to this court before she passed, months before she passed. She stated that it was his will for Teddy Papillon, my client, to have this property. And
Now, who are the plaintiffs in the case? What are their relationship to Mr. Papillon?
Your Honor, I believe that the plaintiff was the grandson of Mr. William Papillon, and Mr. Teddy was
His uncle.
son. So it's an uncle and a nephew that are at issue here. The will of Mr. Papillon, the decedent, was executed in 2007, and that set out his desires for his estate planning. And that will to my client, the plaintiff, this tract of property. So even if Ms. Husted was intending to.
So the will gave it to your client and the deed from the attorney in fact gave it to your client.
in joint ownership, though. It wasn't a lot of state, it was in joint ownership.
With survivorship.
Survivorship.
How old was he when he did that?
How old was William Papillon? He was in his 80s.
I was pretty low risk conveyance survivorship like that, but happens, better in a life estate if you want to keep control, Okay, well, I've heard your arguments. Now I'll read your briefs and I'll get you out something shortly. Thank you for presenting this case very well, both of you, but it's not the case that I look forward to deciding. These two parties have not met to try to reach an agreement, or is it too personal?
We're open for that. We're open.
Well, I would suggest that you consider mediating this. I don't know what the value of the property is, but I will tell you that no matter what I rule on this case, this is not a cut and dried thing one way or the other, in my opinion. I think that the Court of Appeals or Supreme Court could do some dancing on this stuff. I remember when the other case came down, I had lost a case previously opposite to that ruling years, and I was pretty hot about it, because I got walked over on it, and then they essentially changed the law, and then the legislature acts. you know, with Mr. Vincent's a judge now, and he's a good lawyer. Good lawyer. Okay, well, thank you all very much, and I'll try to get you something out on it.
One matter, Your Honor, you still have to take part of that. Your Honor, would it be able to do so? The materials that I did receive from the LRC.
I'm not interested in that. I appreciate it. I know what your argument is on that.
Okay.
Yeah,
Thank you.
I was considerably heavier then, though, than I am now, so. But I had more hair. I don't like to look at those films very much. Okay. That's, we have now, is the next thing we have a confidential matter? Is there something, have y'all worked out your thing?
We've got temporary.
Okay, well, bring it back around. Okay,
Good, we've got a temporary agreement in this case. I will
Okay.
Use this to writing and tender it to Megan for your signature.
okay,
I didn't place an agreement on the record. Mr. Nelson will visit with the children, every other weekend from Friday at 6 to Sunday at 6. Every Tuesday after school until he will take the kids to school Wednesday morning, and every Thursday after school until 8 o'clock. All visitation exchanges will take place at 911. Both parties will drop the DVOs against one another and enter a usual civil restraining order with essentially no violent contact toward one another, no discussions with one another.
status quo.
Except about the children, status quo, and nobody talking derogatorily to one another about the children.
Very
or
important.
Discuss the case of the children.
Okay,
And lastly, they are considering going to counseling,
Yeah.
but we're not gonna make that decision today. Let them think
Yeah.
about it.
well, sometimes things have gone too far for that, but I urge both of you to reflect upon that, you know.
Right now, we want to label this as interim temporary order, because we're gonna try to set a date with Mr. Song.
Yeah, just put temporary. You don't have to put interim in it. It's just a temporary order.
During this
Now,
time-
as far as your DVO, EPO, you agree that you feel safe to drop it? Is that correct?
No.
And you do too? Okay. Well, let me tell you what, now that y'all on my radar screen, both of you, be very careful. And if you think this was a false accusation, you need to be careful not to be in contact or in the presence without a witness, or not to talk on the phone. And you need to be the same way too, just out of abundance of caution, because I don't want to pick the newspaper up and say that we misread this situation, somebody gets hurt. It's not always the woman that gets hurt. Because if somebody's afraid of you, they'll hurt you sometime. So everybody needs to be careful. Thank y'all for working through this thing. Get me a copy of the order, circulate it. And then we'll, the best thing to do would be to work through, we'll not have a bunch of hearings and stuff, and try to work through the property part of it too. And I suggest mediation on that, but it might be easier to go to the commissioner and cheaper sometimes, but this needs to get over with as far as that portion of it. But if you have counseling, you won't have to go through this property situation as much, you know. And I had a friend that said that he built a house once and paid for it twice. You know, and when you do that, it dissipates the assets of everybody, especially the children. Okay, well, thank y'all very much for your work on this thing, okay? Okay, is the next thing we have, the only thing we have list is the confidential matter?
Wait on